Thank you for participating in the NIA and NHLBI Entrepreneur Workshop Series. This workshop covers the topic of intellectual property. This breakout room, moderated by John Darling, discusses the topic of patent application process.
And what we consider to be inventorship in the United States is it's a test. It's sort of a subjective test, but it's when the inventor forms in their mind a complete concept of the invention that it will work. And you have to reduce that to practice. One way to reduce it to practice is to make a model, or to have a working version of the invention. It's not required to submit a model to the patent office anymore. Generally, what we consider to be a reduction to practice of the invention is writing an application that's sufficient under the law, meaning it discloses enough that somebody who has of ordinary skill in that particular field of endeavor or that art could make and use the invention by reading the application without doing undue experimentation. Meaning you have to give them enough so that they could eventually make and use the invention. The experimentation can be long. It can be, depending on the art. Some of the arts are recognized in the law as being more unpredictable than others. And so in an art that's generally got some unpredictability, like chemistry or life sciences, the experimentation can be more than would be in, say, an art that's well developed, like internal combustion engines or vehicle transmissions or something that is mechanical and regarded as generally a predictable field of endeavor for those of skill in the art. If the inventorship is incorrectly listed on a patent, the patent can be invalidated. It has happened. It's not a frequent occurrence, but it is important that the inventors be listed correctly. There are procedures. Certainly, if you're working with a patent attorney, they should always ask you, who invented this, or before the application's filed, they should show you a version of the claims, and they should say, everybody who's going to be listed as an inventor, because you are required to sign a declaration or an oath that affirms that you are. The U.S. is very specific on that. We're really the only country in the world that requires that. But you are required to read the application and affirm upon your signature, and some pretty serious penalties under the law for not being truthful, that you are an inventor or a co-inventor of the material that's disclosed in the application and claimed. So, for me, I tell every inventor that I work with, a lot of people are going to read this application and this patent, but the only person who's going to have a pen put in front of them and told, sign your name under penalty of a couple $1,000 fine or some time in jail, that it's accurate and correct, is you. So whoever you have drafting your application and representing you should take that very seriously with you, that they're making sure that the people who are going to be listed in the initial filing of the application are the inventors. It is possible to change the inventorship during the application process and after the patent is issued, after it's granted. Those procedures are, fairly routine. There should be a check at the end, right before the patent issues. Whoever's representing you should say, here are the claims that have been allowed. Everybody please confirm that you did invent or co-invent at least one of the claims of the subject matter, and before they go ahead and pay the fee. That's just what we call good hygiene in the patent practice. It's not, the number of patents that have been invalidated for the wrong inventorship is probably only a handful, but it's not the number, it's the fact that if somebody thought it was important enough to invalidate the patent on an incorrect inventorship, that the patent must have been worth something to somebody. That's generally, so in patent law, it's sort of the infrequency of certain events is more of an indication of their importance than the frequency. So I'll just go through the questions kind of in order. Somebody asked, how do we make sure the claims are as broad as possible? from my experience, as Gautam mentioned, I was an examiner for 9 years. I was in private practice for 13 years, and I'm back in private practice. And I worked for a very large company at their global research headquarters. And the way you make sure the claims are as broad as possible is you're not required to do a search before you file an application, but doing a pre-filing search is a good way to do it. It's important that you have the claim searched the way an examiner would search your application. There are many search firms that are staffed by former patent office examiners and officials, and they do a fairly good job. If you present them a set of claims and a disclosure and say, find me the prior art that the examiner would find, and then have your attorney look at that and get a sense of what the prior art is, and then draft the claims to make sure that you avoid the prior art, meaning your claims are novel, they're new, and they're not obvious. The examination process is invaluable for this. Examiners use a standard of examination we call broadest reasonable interpretation, which means they give the claims a reading or an interpretation that includes aspects that you may not have thought of when you wrote the application. You go in saying, well, we intend this term to mean this. And the examiner says, well, it's possible it means this and that. And so they will find art. And so you have to engage with the examiner in the process to make sure that your claims are addressing the examiner's and the examiner's concerns. Because as I mentioned in the opening, the examiners are charged with the trust of making sure they don't grant patents on subject matter that's known or would have been obvious from what is known. The pre-filing search and the examination process are the means by which you obtain the broadest claims that you're entitled to. The law says you're entitled to a patent. It doesn't say the scope that you're entitled to. That's on you and your agent or attorney to determine with the examiner. Somebody asked about the patent application process underlying IP expansion strategies for an existing broad scope of IP. The U.S. has what we call continuation practice, meaning you're not limited to one application as long as you file a second application, either voluntarily, which we call a continuation application, or a divisional application, which is the result of an examiner. The rule is one patent, one invention. And so if the examiner determines that you have more than one invention in your application, the examiner can require you to select one for examination and issuance. And the law provides that you may file a second or a third or however many is needed to cover the additional inventions. Keeping an application, continuation or divisional pending allows you to present claims of varying scope, sometimes broader, sometimes narrower. If you present claims of broader scope, you do run the possibility of the examiner making you file what's known as a terminal disclaimer, meaning the examiner can require that you own or that you own both patents or multiple patents, and promise not to assert them or to assign them or license them to separate groups or separate individuals or companies due to the disfavor the courts have with multiple parties asserting patents that come out of a single application. So you don't, if you get a patent for invention A that you disclose and a patent for a continuation for a slightly narrower version of it, you have to maintain ownership of those. You can't license the narrower version to somebody else and then also have them out suing companies for infringement. So you have to keep that in mind, that you are allowed to have more than one patent on your invention, but you do run the possibility that the examiner will require that you commonly own them, that you always maintain ownership of them. There's also what's known as a broadening reissue application, and it must be filed within 2 years of the grant of your patent. So if you get a patent and you think, oh, I made a mistake, I didn't need to have this narrow feature in a claim, you can go back to the patent office and allege that you made a mistake and you'd like a broader claim. The reissue application process is it's taken very seriously by the patent office. They have a special unit dedicated to examining those applications. The examiners are all very experienced. They work in a team environment, and one examiner signs all of the correspondence, but they do jointly make decisions, and they all stand behind the decisions that get made. It's a process that the patent office has really strengthened over the last 10 years or so. It's also possible to get a narrowing reissue application, meaning if you think that your patent may be invalid by some prior art that you weren't aware of, you can narrow the claims to avoid that. There's no time limit on filing a narrowing reissue application. You can file at any time during the term of your patent grant. Somebody asked, are there any recent changes to the process? Well, like I said, I've been practicing for 22 years, and so the patent office is probably one of the most dynamic agencies in the executive branch. Their processes are ever changing. There's folks like me. We read the Federal Register notices every week, and the patent office publishes its own version of the goings on there every Tuesday. They call it the Official Gazette. And so there are changes to the rules. There are new procedures, new programs at the patent office. Pretty much every, not every week, but like there's currently a sort of a pilot program to fast track applications that allow for the treatment of COVID-19. So if you file an application and you think it has applicability to COVID-19, you can ask the patent office to fast track your application, to speed up the examination. And they've had programs like that. Over the course, they had one for green energy. They've had other various programs for bringing life science applications and patents into the process faster. The patent office is they have an entire unit there that just writes the rules and proposes new rule changes on a fairly frequent basis. And attorneys are sort of required to keep track of these and make sure that they're submitting all their filings in accordance with the most current version of what we call the rules, which is the federal regulations that cover the patent office, Title 37. Somebody asked what types of disclosures of proprietary information can jeopardize a company's ability to have a patent claim allowed. In the US, we have what's known as a grace period, meaning you can disclose your invention to others. It's not to the public, but it's to others. Anybody who is essentially not an inventor, not meaning, of course, your employer, inventors who are working for their employer obviously disclose their inventions to their employers, but meaning if you disclose your invention to anybody and you don't do it under a non-disclosure agreement, meaning you transmit this information freely, you have essentially started the clock running. And in the US, we have a grace period. So we have a year. If you disclose your invention, you have 1 year to file an application or you lose rights to it. The rest of the world has an absolute novelty requirement, meaning if you disclose your invention to anybody before you file an application, you lose all rights to it. You cannot file if you're in Europe and you attend a conference and you're a speaker and you present your paper, and then like the next day you decide, oh, I should have filed a patent application on that. It's too late in Europe. Your rights are gone. the types of disclosures that can get people in trouble. In the US, the standard is if what you disclose is ready for patenting, then your disclosure starts the 1-year clock running. You're into the grace period. What does that mean? Ready for patenting? It's a disclosure that would essentially allow somebody to, know what your invention is. So people have lost patent rights for offering for sale. Offers for sale are a big example in the law of people who have lost their patent rights for they had an invention, they offered to sell it to somebody, they find out that the invention is popular or marketable, and the 1 year passes and they haven't filed an application, and they realize, oh, I needed to file, and they didn't, and so they lose their patent rights. But I have seen cases where folks have presented at conferences or at sales events, and their slide deck, their PowerPoint presentation is enough to cause them to lose their rights. Poster boards at various conferences, and it's not simply that you can't defend your sort of disclosure on the grounds, well, I didn't give a copy of the poster board or the PowerPoint presentation to somebody. It's the simple displaying of it and the discussion of it that starts the process. You've essentially disclosed your invention. It was ready for patenting. You have 1 year in the United States to file an application to protect it. Those are, those things have happened, and it's, I used to work, like I said, I used to work for a big company, and we, that was always a fear for us, that one of the engineers or researchers would go and attend a conference and say something or show something that they shouldn't have. That was constant advice that we gave out to the researchers where I worked. Are there any pitfalls or risks that should be avoided when writing grants that reveal part of your IP, so as not to jeopardize the chance of protecting the IP through a patent? I'm not sure how it works when you're asking about writing, when you're applying for a grant, but that is a if the process is open to the public, if the public is allowed to see what is submitted in order to get the grant, there is a risk. Generally speaking, though, like the company I worked for, we did a lot of DARPA and EARPA RFPs, and what we did before then was we always made sure that any technology that we'd already developed that we were going to bring to the table to get the grant or the award was subject to a patent application. Sometimes that's as simple as taking the material and putting a cover sheet on it and filing it at the patent office. It's a provisional patent application. But you need to understand the process. If the process is open where people can see what you're submitting, you run the risk of having somebody say, well, when they applied for this grant, they disclosed all of this and they didn't file an application within a year. That would be a very highly fact-specific determination by a court, but it's generally a good idea when you're bringing technology to the table in order to get a grant or an award, or to be the successful bidder of an RFP, that you have some protection in place already. Generally, for us, it was file a provisional patent application, which is a fairly inexpensive process and a fairly simple process. It's essentially, you don't have to write claims, you don't have to have the disclosure in the format that, for example, Gautam is talking about, which is a very regimented way of presenting the material. You just put a cover sheet on it and say, the inventors are, A, B, and C, and submit it and pay I think it's $160 fee. It's fairly small, and it's even smaller for small entities and micro entities. And what public disclosures of data would jeopardize patentability, exclusivity of university-owned IP? Again, it's publication of journal articles or papers. When I worked where I worked, we had a manuscript submission process, meaning inventors or researchers that we had were not allowed to publish articles until the patent attorneys had reviewed them to make sure that either the subject matter was already the subject of a patent application or to get a patent application on file before the articles were published. But again, it's also, as I said, it's appearing at conferences and speaking, everything from PowerPoint presentations to poster boards that may make up exhibits at conferences that researchers and inventors may speak at are all possible ways to, and again, in the US, you don't lose your rights when you disclose, but you do start that 1 year clock running where your grace period is, you have to file before your grace period ends in order to make sure that you don't lose rights to it. And some research may not suggest a patentable invention until after research has been published. How can we limit the extent to which publication becomes a prior art disclosure? This has come up recently in some cases. If what you publish does not, as we patent attorneys say, enable what you ultimately claim, then the publication of that research is not a problem. So if you publish a paper that says, well, we've been doing this research and the results are undetermined right now, and then the research, you continue the research and you find out you have a patentable invention and you file the application, the examiner is most likely going to find your previous paper. Examiners do search the names of the applicants. If Fred, John, and Andy file an application, the examiner searches for those names and will find any publications by those named inventors while examining the application. It's, the burden is on you though, if you're going to argue to the examiner that what you previously published does not enable the invention that you ultimately disclosed in an application and presented claims to, the burden's on you. Examiners are aware of that, and they will hold you to that. That happens, and what we call non-patent literature is, in the law, it's not presumed to enable claimed inventions, but the burden is still on you to explain, well, yeah, we disclosed all that in a publication, in a research paper that got published, but it doesn't allow one of ordinary skill in the art to make and use the invention as we ultimately disclosed it and claimed it in the patent office. As a patent attorney, my advice is always file the application first and then publish. But I understand that that's for some folks in the academic or research environment, that's not always a possibility. But you have to keep that in mind, that you will see it later, and you should have your arguments lined up as to why what you previously disclosed doesn't negate the patentability of the application that you file. How long does a typical patent take to acquire, and what is the average length of time for a patent to be granted? In the United States, the process can run, they have programs at the patent office. They have special programs where if you pay money or if your application is directed to certain subject matter, the patent office will guarantee you a decision within 12 months. The typical pendency of an application right now, the US, the PTO used to publish this, but they kind of don't anymore. But it can be anywhere from 2.5 to 3.5 years. I've seen articles written on blogs, patent blogs, If you have to go through an appeal process, the average pendency for an application that must be appealed to get granted is 84 months. So it's 7 years. It's a long process. Much of the time is spent while the application is waiting to be examined. Once the actual examination begins, meaning the examiner picks it up, reads it, makes a determination whether you have multiple inventions in it, and might send you a requirement to select one, and then goes out and searches for the prior art and applies it to the claims that you've presented. That process is very quick. In the US, the examiner issues you an office action, what we call an office action, directed, to whether your claims are patentable or not. And then you get 3 months to respond. You can extend it up to 6, but the process is fairly quick once you get into it with the examiner. And might think, well, 3 months is, who needs 3 months to respond to the examiner? I used to think that when I was an examiner, and then I became a practitioner, and I was like, man, I only get 3 months. it's not enough time. It's the time moves quickly, and you need time to confer with your attorneys. You need time to, read the prior art, understand what it is that it really discloses, what the examiner says it discloses, and that can take quite a bit of time. But yeah, and the term of a patent is it's 20 years from the day you file the application, or if you file a second application, it's 20 years from the first filing date that you have. And there are provisions in the law to extend the term if the patent office caused unnecessary delays, but there's also provisions in the law to take time away if you unnecessarily delay. Those rules are very complicated, and a lot of cases have been fought over how much patent term people get. They're mostly fought by the pharmaceutical industry, because each day of patent term for them is worth quite a bit of money in licensing terms. Does the 1 year clock to patent after disclosing the invention mean you have a year to file a provisional patent, or must it be a full patent? You can file a provisional application at the end of the 1 year, or within the 1 year grace period. It doesn't have to be a non-provisional. But again, filing a provisional application starts another 1 year time period running, in which you must file the non-provisional, or you can file what we call an international application, a PCT, a Patent Cooperation Treaty application, assuming you're still eligible to seek protection outside the United States. So if you file a provisional application, within 12 months, you have to file a non-provisional. And you also have to file in any countries around the world that you want to seek protection, assuming you have absolute novelty, meaning assuming you haven't disclosed any or made any disclosures that are destroy the novelty of the application. Or jurisdictions like Europe and the other, the 5 main patent offices in the world are the US, the Europeans, the Korean Patent Office, the Japanese Patent Office, and the Chinese Patent Office, the IP5 as they refer to them. I understand that there is a 1 year grace period in the US for PCT application following disclosing something patentable in the form of an abstract publication, etc. So my question is, does that protect from going international following US patent subsequently? Again, if you file in the US, within the grace period, you've already lost the absolute novelty requirement for the rest of the jurisdictions in the world. So assume you publish a paper on January 1st, 2021, and you realize, oh, I should have filed a patent application. You're pretty much limited to the US after that. If you're going to file it, now in April or, sometime soon. But if you have absolute novelty, meaning you haven't disclosed your application or your invention to anybody, you can file a PCT application can be filed as your first application. That is a normal route for some applicants, because a PCT application has a lot of usefulness as a placeholder. It gives you almost 2.5 years before you have to decide where else you want to file, or what countries you ultimately want to pursue patent protection in. I'm not sure what you mean by in the form of an abstract publication, but again, if your publication is not enabling of what your invention is, it's not disqualifying. But again, the burden is on you to prove that. And if you publish anything and then you file an application, the examiners will find it. It is that is one of their directives. If you look at their manual of how they approach examination, an inventor name search is the first thing they really do. And if you've published anything prior to filing, the examiners will find it and will press you with it. Examiners are by nature, I don't mean this in a pejorative way, but they are by nature suspicious, and they take their role of making sure that you're not getting a patent on something that you shouldn't be pretty seriously. In the US, obviously, anything you disclose within the grace period is not usable against you, because the law says, well, the disclosure was by you. It's only if you file after the grace period that it becomes an issue, and it obviously becomes an issue in the rest of the world where absolute novelty is required. Again, my best advice to you is file then publish. It's always that's always a safer route. Somebody's asked about the cost for a patent application. What's the budget? I'm assuming this is a question about the costs for an application are the fees that the government charges are set by rule. There are, at the U.S. Patent Office, there are 3 levels. If you're a large entity, meaning you're a business that has 500 or more employees, that they have a fee structure for that. They have a fee structure for small entities, which are businesses less than 500 employees, and then they have what's called micro entity status, which is tied to a shifting definition in the IRS code about the median adjusted gross income. So you have to be within a particular, below a particular income level in order to apply for micro entity status. As far as what's the budget for, if you're asking about how much does a patent attorney charge, and what can you expect to pay for legal services? Those are all negotiable with your attorney. The work I do is mostly for big companies, and we have rates pre-negotiated with them. But I do write applications for individuals, and I negotiate those with them in advance. It's part of a negotiation that you engage with an attorney before you start the relationship. An attorney should present you with an engagement letter that includes a retainer for their services, meaning what you're getting is the attorney's agreeing not to represent anybody besides you for that particular matter. And you can negotiate the price. Applications can run from anywhere from $4,000 or $5,000 to $20,000, depending on the complexity. Obviously, the technology factors into that, because attorneys who deal with particular technologies, may be in a short supply. I mean, I don't have a life sciences background, so if you came to me and asked me to write an application for, a pharmaceutical or, some other type of life science invention, I'm not qualified to do it, and so I would have to refer you to somebody else. And those folks have all the business they can handle right now. They're in high demand, and they can charge fairly high fees for their services, and I'm sure most of them do. That's the market. That's how legal services get distributed, pretty much. Those that need, pay for it. So the next question is explain how to select a jurisdiction for a patent. Again, as I mentioned in the opening, where you first file is determined by law. In the United States, if you're a U.S. citizen, you have to file in the United States first, unless you receive from the U.S. Patent Office what we call a foreign filing license, meaning you, the U.S. Patent Office, and you say, I have this invention and I want to file it, say in Europe first, because the market in Europe is better. The Patent Office will look at your invention. Generally you go in there with an application already drafted, that you're ready to file, and the Patent Office will determine whether you're allowed to file it outside the United States first or not. Every other country in the world has the same requirements. Some of them are based on citizenship, some of them are on where the invention was made, meaning if you were a citizen of, take for example, Poland, and you're working in the United States, the Polish law, I don't know, this is just an example, but the Polish law may say, well, all Polish citizens have to file in Poland first, regardless of where the invention was made. And in that case, that Polish citizen is going to have to get a license from the Polish Patent Office to file in the United States first. So every country has its own laws, and it's generally based on citizenship and/or where the invention was created. Your patent attorney or agent that you're working with should definitely ask you your citizenship and where you were when you invented the subject matter. As far as jurisdiction for a patent, meaning, well, once you've satisfied the initial filing requirements, where should you file? It's the jurisdiction you should file in, or jurisdictions, is dependent on the market for your invention. If you want exclusive rights to your invention in Europe, you need to file a European application. If you want exclusive rights to your invention in China or Japan or Australia, you need to file in those countries. Obviously, the market is something that you need to determine for your invention to make it worth your while to file in those countries. And essentially, enforceability of your patent in those jurisdictions is an important factor too. Just from my own experience, I know that in China, it's very difficult to get money damages, but it's fairly easy to get an injunction, which is sort of the exact opposite of how it is here in the U.S. The U.S. is very good at giving money damages, but not very good at giving injunctions. So how you enforce it, what remedies are available, how important it is for your success in that particular jurisdiction market are all factors that you need to look at when you decide where you're going to file. And filing around the world is an expensive process because you have to, again, attorneys cannot represent you in the European Patent Office or the Japanese Patent Office. So you're engaging a whole nother lawyer or agent in every country that you need, or every jurisdiction that you need a patent. So someone asks, can some elements of an invention be kept as a trade secret? This is a great question. The U.S., in the U.S., the requirement is that you disclose your invention in a manner sufficient for one of ordinary skill in the art to make and use it without undue experimentation. Now, as I tell all the inventors that I work with, a patent application really is a snapshot of the invention at some point in the process. It's very rarely do inventors walk into my office with a complete invention and say, here it is. Everything that it can be developed has been developed, and everything is perfect. And I'm not going to do any more work on it. You're not required to disclose every single facet of your invention. And so if you determine that your composition works with element X in a range of 5 to 17%, you can disclose that. If you determine later that it really works great when element X is 11%, after you file the application, you're not required to go back and tell the patent office that. having disclosed that it works between, with element X and the composition being 5 to 17% is sufficient. So you have to balance between what you need to disclose in order to enable it, to allow somebody to make and use it, and what you don't have to disclose to make the best version of it. The US used to have what's called a best mode requirement, meaning the examiner could reject your application if you did not disclose the best mode of making and using your invention. That provision in the law was taken out, but it was retained as a defense for an accused infringer. So if you sue somebody for infringement of your patent, and they can prove that you purposefully withheld the best mode making and using your invention when you filed the application, they can invalidate it. It's a very sensitive determination, and it's hard to prove. Again, you're not prohibited from further developing your invention after you file and discovering things about it. You can discover new advantages or new unexpected results of your invention after you file, and you're able to rely on those in the patent office to bolster your arguments as to why your invention is patentable. But you can't, at the time you file the application, purposefully withhold information that would be necessary to make and use it. But yeah, there's know-how, and there's what we used to call, where I worked, the secret sauce of your invention that may not always make it into the application if what you've disclosed is enough to enable making and using it. What are the common mistakes new companies make in developing IP that should be avoided? Patents versus licenses. Most people don't understand that a patent is what we know what's called a negative right. It doesn't give you the ability to make and use, or what we say, practice the invention. It allows you to exclude others from doing it. And you also have to remember that your patent may be subject to other patents. So if you have a patent on ABCD, and somebody has an earlier patent that's still in force on ABC, you may be infringing there. So you not only do you need to have a good understanding of what your exclusive right is, you also need to have a good understanding of what other individuals or companies' exclusive rights are, and making sure that you can avoid them. It doesn't give you the right to practice your invention. It gives you the right to exclude others from practicing your invention, and you will be subject to that from other patent holders, as you may hold others subject to your patent. So, how do you coordinate publication of research with patent applications to avoid disclosure prior art rejections? So I kind of mentioned this before. It's important that before you publish anything, to have a patent attorney look at it if you're ultimately going to want to file an application. If you work, for an organization that has, like a tech transfer office, or where I worked, we had, we had 13, patent attorneys sitting on the hall, and we had a tool, that allowed the researchers to submit their manuscripts in advance before publication to review. But you really need to look at what you're publishing and figure out, would this be a problem later on if it became prior art, meaning if we published this and then failed to file within the grace period. It's and as the inventors, you're the best in the best position to determine what could somebody understand from this. What would this enable others to make and use? And so you should definitely be asked those questions if you want to publish something. Do you need a patent lawyer to apply for a patent application? What extent can we make changes in the provisional to the non-provisional? The patent office doesn't require. You can represent yourself at the patent office, but as I mentioned in the opening, if you're going to use an attorney, they have to be registered by the patent, or an agent. You have to be registered by the patent office. The patent office has a a group within the Patent Office called the Office of Enrollment and Discipline that writes the rules for attorney conduct before the office and enforces attorneys' behavior and compliance with the rules before the office. The Patent Office has a myriad of rules that have to be complied with, in every interaction with them. And the office maintains a roster of registered practitioners. It's on their website. But you can represent yourself. The Patent Office does have they have programs to aid what they call pro se applicants. I'm not, the extent to which the examiners in those units may be intimately familiar with the technology you're disclosing and claiming is, it's probably not extensive. The group is not that big, and you're taking a risk relying on the Patent Office to determine the full scope of the protection you're entitled to, because, as I mentioned, their mission is to protect public interest. They're going to err on the side of caution and want to give you narrower claims than a practitioner or a registered patent attorney or agent might get you. What are the specific requirements for a software patent? Well, software is one of these areas of technology now that has been debated endlessly by the courts. I would just say, as a quick and dirty answer, software has to be, if you're going to have a software application, it has to do more than just simply provide some generic or some functionality to a computer. The courts have basically been saying, if you're going to have software, it's got to improve the performance. It has to be an improvement to the performance of the computer, or it has to solve a problem that's unique to either the computer or the internet. It can't just be a software application for scheduling employees, shifts, in a business, or maintaining a calendar, or tracking inventory. It has to, if it doesn't improve the function and the performance of the computer, or it doesn't solve an issue unique to computers, the computer or the internet, it's going to be deemed to be ineligible subject matter. It's that area of the law literally changes every day with each new court decision that comes out. What can you tell us about different territories? How much territory enough? I'm not sure what this question is referring to. Again, for jurisdictions outside the United States, you need representation basically to guide you through their processes, their patent processes, and all those offices around the world. How much territory is enough? There's no way to a universal or a worldwide patent. There is a way to get sort of a worldwide examination, but in terms of getting a patent that's enforceable in every jurisdiction, it's not possible currently. Every sovereign country essentially decides for itself what patents it wants to grant and allow to be enforceable. And again, I answered this at the beginning, can including the name of an inappropriate person on a patent invalidate the patent? Most definitely. This is, I have represented many large companies. The naming of the manager of the lab was sort of a custom or a practice. And, I've had to disabuse folks of that practice more than once. I've had to get people in a room and say, okay, here's the claims that we're going to present, or here are the claims that allowed. Everybody read them, and if you can't tell me, if you can't point to one claim on the paper that you invented or were a co-inventor of by conceiving of what was claimed and reducing it to practice, then you're not an inventor. Those are always uncomfortable meetings, but definitely incorrect inventorship is a grounds for invalidating a patent. And like I said, it doesn't happen often, but if it does, it's because it was serious and it was important. and you don't want that to happen to you. Can you explain the freedom to operate assessment process that's an importance? Freedom to operate is um, a process where you look at the prior art and you look at your claims and you make an assessment of whether what you're ultimately going to be given as a claim scope, as an exclusive right, does it is it impacted by anybody else's exclusive right? So as I said, if you get a patent claim and it says an apparatus comprising A, B, C, D, that's good. But if somebody else has a patent to an apparatus comprising A, B, and C, you really can't practice A, B, C, D without infringing the patent on A, B, C. And so freedom to operate assessment is, we did it where I worked, and it's a process where essentially you're doing a search, and you can limit. You don't have to worry about patents that are expired. All right, so you don't have to worry about a patent from like 1975 because that patent's not going to be enforceable. Its term has expired. So it's what goes on is you do a search, you limit it in time to patents that may be still enforceable within a reasonable time frame. As I said, patents in the U.S. are enforceable for 20 years from their filing date. And you also have to go in and look at whether the patents have been maintained. In the U.S., you have to pay a fee every 3.5 years or so to keep your patent enforceable. So it's a constant process because essentially as your application is winding its way through the patent office, other applications that were filed are published. Patent applications are published 18 months after they're filed. And so you won't know who has an application in before you until, essentially all the applications that were filed 18 months before you get published. And so the freedom to operate projects I've worked on, we either had monthly or weekly calls, and the patent office the U.S. Patent Office publishes applications every Thursday, and they publish issued patents every Tuesday. The Europeans have what they call I want to say it's the Journal, or maybe they call it the Gazette too, where they publish what they call B1 publications, which means B1 is a code that says we are going to grant these inventors these claims, and essentially what happens is attorneys like me sit in a room with a stack of published applications or granted patents or patents that are going to be granted, and we look at them and say, does this in any way affect our right to practice the claims that we might ultimately get? And those projects are long and require a lot of manpower and are expensive, and so they're mostly done. My experience with them was for clients that I represented in the company I worked for, where there's going to be what we call an NPI, a new product introduction, meaning we're going to put this product out into the world, into the market. Are we going to get sued for patent infringement? And the answer is never. It's not binary. It's not yes or no. It's it's maybe, but we have really good arguments why it doesn't infringe. And those, once the product goes out into the market, a lot of fingers get crossed, and you hope that your assessments were correct. But it's huge. I mean, there are stories out there where products get introduced, and a week later, a judge issues an injunction ordering that the products be impounded or taken off the shelves, or not allowed to be imported to the country. And that's a major failure on the part of the company's attorneys, the client's attorneys, to make the correct assessment. And thankfully it's never happened to me, but every time I read about that happening, I say, there but for the grace of God go I, because you know, those are very stressful projects to work on, and you know, if they're done correctly, they're invaluable to the client or the company, and if they're done incorrectly, they could be a major disaster. So, are there any other questions? Okay, I see here a question. It says, if the university does not see a commercial value in filing a patent, what are the alternatives? Well, in the United States, again, you have to look at, we have laws here that require, you may be in a situation where you're required to assign your rights to an invention to your employer, depending on where you work. And some of these agreements also cover any invention that you work on or invent, even if it's not related to the company's business. If your question is, well, what's the alternative for the inventor? I'm not really sure there are any. You know, if the company doesn't want to file an application for it, you know, you're sort of out of luck. You know, that happened where I worked. You know, inventors or the researchers submitted invention disclosures, and the company said either we don't think it's patentable or we don't think it's valuable enough. And you know, the inventors, the researchers were, you know, some of them took that badly, and some of them were like, well, you know, just move on to the next project. So I'm not sure I answered your question, but
so my question is, a related question is, how are drugs developed for uncommon or rare disease how are they protected intellectually?
Oh, like orphan drugs, you know,
Yeah,
drugs
yeah,
for orphan diseases.
because there's
Well,
not much commercial value in those in terms of filing
yeah,
the patent and the fees.
right.
And
The market is not.
yeah.
Yeah, I mean, those are protected in the way, you know, any pharmaceutical would be. You know, there's the patenting of pharmaceuticals is complicated by the need for, you know, FDA approval. In the, you know, most companies don't want to go through with getting a patent on a drug that the FDA is ultimately not going to approve. In terms of patentability, their patentability would be determined according to the, you know, any other pharmaceutical. I mean, if you invented a cure for cancer, you know, or you invented a cure for a disease that only afflicts, you know, 1,000 people a year, the process is the same. Whether the company would consider it worth getting patent protection on a treatment for you know, an affliction for 1,000 people a year is up to them. Most of them probably would, because the expense involved in getting a patent compared to the expense of getting it approved by the FDA is fairly you know, insignificant. And you know, I think most of the companies you know, who are going to make orphan, you know, drugs for orphan diseases, the publicity is, you know, probably as valuable as any patent that they would get on it, or more valuable. I mean, you know, it's not always about you know, licensing or you know, exclusive sales with these companies. And again, but if you're the inventor and you've come up with you know, such an invention, it's more than likely that the company's going to own the rights to it. And you know, it's up to them whether to seek patent protection. Certainly, you know, inventors within companies have been known to lobby or, you know, be persuasive and getting the company to do that. You know, I mean, I had inventors who came in and you know, pressed their case with me, and sometimes we did and sometimes we didn't. I mean, it's, you know, it's a business decision. The ultimate patentability of the invention is just one consideration, and and we had a very elaborate process to determine whether we would file an application for something in terms of its value, ultimately the company. If there's no more questions, thanks for your time, and I hope everybody got their questions answered, and thank you.